Good afternoon. We're here for oral argument on Maywald et al. Versus Toyota et al. Our number CV-25-0009. A couple things before we get started. Obviously, we are in a different place than we normally are. So you guys are a lot closer to us than we're used to. And on the same level, usually looking down. Very, very different. So the microphone is on for you the entire time. Each side has 20 minutes as per normal. You may keep whatever time you wish for rebuttal. You have to keep your time yourself. And with that, please begin.
Good afternoon. May it please the court. Wendy Loomish and Amanda Heitz from Bowman and Brook here on behalf of the Toyota defendants. And I would like to reserve 3 minutes for rebuttal. I know I need to keep my own time here. This case presents a straightforward application of existing Arizona law on strict liability. Our position is that the Court of Appeals abandoned several settled principles. Toyota asks that this court vacate the Court of Appeals decision and affirm the summary judgment based on essentially 4 points. In a strict liability case, plaintiff is required to first prove that there was a defect. After that, they look at whether or not the defect made the product unreasonably dangerous, and of course, causation. Second, in this case, plaintiff did not prove that the vehicle was defective as designed because plaintiff couldn't point to a characteristic of the vehicle that made it defective at all. The third point is assuming that there was evidence of a defect presented. Properly applied, the consumer expectation test would preclude liability. And finally, assuming a defect, there is no liability under the risk-benefit test. So let me walk through each of those, if I may.
You do. As you walk through it, when you get to the consumer expectation test, that's a test that confuses me at least a bit in terms of it seems to duplicate a bit the separate definition of is it a defect in the first place. So are those indeed, as you go through, the same thing that you're looking at twice, whether it's a defect and then is it unreasonably dangerous? And if so, why don't we just combine it into one?
Well, and I would agree with you. It is a little bit confusing, but I do believe that there is guidance going back many, many years from the Supreme Court in this area. There is law, the Dart case, the Ridenauer case, the Burns case, the Rogers case. Each and every one of those cases very clearly say, first you prove a defect, and then you look at whether or not it's unreasonably dangerous. Now, why is that important? Because as Your Honors pointed out, it sounds like these concepts are mixed together. The reason it's important is because if not, a manufacturer would become an insurer for any instance where there has been an injury. There's an injury, it would automatically mean liability if there wasn't some proof that there was a defect. And the Galanka case says anything different. That's probably one of the more recent cases that talked about this issue, and it says it as defective, unreasonably dangerous, which is the language of 402A, so that's probably where that comes from.
I think correct me if I'm wrong, Madam Chief Justice, but I think where we're both having problem is even in terms of separating out the elements, the consumer's expectation seems to be an element in both proving that a defect exists and then in the consumer expectation.
Actually, I would say it's an element of defect, it's an element of the consumer expectation, and it's even an element of the risk-benefit test.
Alrighty then, please separate them.
It affects all of these. Let's look at the issue of proof of a defect. It's the definition there, it's a condition not contemplated by the ordinary user, which will make it unreasonably dangerous or unsafe for normal use, which is where the confusion comes in because you start talking about unreasonably dangerous. And in many cases, it's not a big deal that we don't talk about it. For example, in Galanka, it was a park to reverse case. It's not that difficult in a case like that to say, if the vehicle suddenly reversed when it wasn't supposed to, there's a defect. So now let's go to the next step. Very different here. Why do I say that? Because in this case, there is no evidence of a characteristic that made this vehicle unsafe. It wasn't a problem of it veered off the road. It wasn't a problem, as in some other cases, of a propensity to roll or some other problem like that. The fact that the car is required for the driver to steer the vehicle doesn't make it defective. Everybody knows that. The law requires it. The statutes require it. We all learn that when we get our driver's license and we go through driver's ed in high school. Everybody knows it. So that doesn't make it defective. The vehicle complied with standards, and I'm not suggesting that compliance with standards is the be all and end all, but it's an important point here because through all of these years, the lane departure warning is not a requirement of the government. They have still not passed any requirement that happen. So if this vehicle is defective, then every vehicle that doesn't have a lane departure warning, or let's go to any other new technology, because in these emerging technologies, this is coming up a lot, every vehicle on the road that doesn't have these technologies would be defective. That clearly can't be the case. And in fact, the concurring opinion in the Court of Appeals, I think, is trying to make that point when it says something along the lines of, you might get to a point where having a driver-operated vehicle makes it defective in and of itself. So the defect issue is really critical. Now, what my opponent will say is it's defective because of the absence of a safety device, that there was something else you could have done. That's not the law in Arizona, and it's not the law in most jurisdictions. A vehicle that otherwise is safe is not defective because there's not some additional safety device.
Where do we, it sounds easy on the extreme edges of things, possibly, like
Always
self-drive. Yes, always. It's the gray area that we're dealing with. So I think that the restatement says a defective condition is one in which makes the product unsafe for normal handling and consumption. And you just said, and you said in your brief, well, we made a car, we designed a car. It does exactly what a car does. It drives on the road and lets people drive and park and stop and all of that kind of thing. But there are also consumer expectations regarding safety. So, certainly forgetting that it's also now required by law, it's an expectation by a consumer that there will be a seatbelt in the car. That doesn't have anything to do with how the car drives, but there's an expectation, I think, that it will be there to keep you safe. If there's a collision, which unfortunately happens all too often, there's probably an expectation that for most people who don't know the law out there, but there's an expectation, well, there's going to be airbags, most likely, if it's a newer model of car in the last 15, 20 years, whatever. So how does that expectation regarding something that has nothing to do with how the vehicle actually moves figure into your definition of defect?
Well, I think I would answer that in part by saying, if you look, for example, at the Breadhauer case, which happens to be the case on seatbelts, and there was an extensive discussion about what does it mean, and now I'm jumping to consumer expectation test, but I think it all fits together. What is that expectation that we're looking at? The ordinary consumer expectation is that you must drive your car. You must pay attention. The manual tells you, the rules of the road, everything tells you you must operate your vehicle safely on the road. You can't just say somebody else is going to take care of it because there's a lane departure warning in there. And I think that's a little bit different than some of the other references you had were to crashworthiness cases, where you're talking about, in the event of the collision, being able to protect the occupant in that event. This is a straightforward case of, what are you expecting when you get in your car and you drive your vehicle? The one thing I would say that the district or the Court of Appeal got right was the court said ordinary consumers right now have no expectation about lane departure warnings. They're not expecting it in their vehicle. They're not ubiquitous enough that it's out there for people to expect. What ordinary?
Well, go back to the tests, and I know that you, of course, want to talk about the forerunner and this case and resolving this case. But at the end of the day, we're going to write an opinion about this that's going to give guidance for future cases with all different kinds of scenarios in which that kind of line drawing is very important. So taking what I said about it's not just making the vehicle go, or there's a certain, I think you'll agree with me, wouldn't you, that there's a certain level of legitimate consumer expectation about safety. Would you agree with that?
I would agree with that,
yeah.
generally.
So generally. So even if your position is, but nobody knows about lane departure warning unless they've read this thick, or not many people have an expectation, and particularly if their car is not the A-level trim or whatever that they've paid for. How do we give guidance to these future cases about what to look for legitimate consumer expectations? Is it just things that are required by law to have, or what is, How do we draw that line in that very gray area?
I think that what you have to do is you have to look at the particular product and you have to say, as designed, was there something defective about it? And if you look at different cases, you can make that separation. I think you can do it on, for example, the park to reverse. You can say, as designed, I don't expect it to go from park to reverse. You can do it on some other cases where the Gomolka, which is a case that the plaintiffs rely upon, it had to do with the fumes that were getting into a steam cleaner, and they were saying, to use it properly, that those fumes are going in there and they're lighting a fire. That's something that as it sits there, it is defective. It's not safe for normal use. This is not that type of case. And the line drawing there, when you look at the cases, are those cases where in its normal use, it is operating safely and there's no problem with it. I'll compare that, for example, going all the way back to the Estabrook case, which is a helmet case. And in that case, they found there was a jury issue on defect because a helmet is designed to protect your head in a collision during a football game. And they found that it violated some ANSI standards that related to how that vehicle should perform or how that product should perform. And therefore, in that instance, you've got a characteristic of the product that is making it unsafe. You don't have that characteristic here. There's nothing about the vehicle itself that makes it unreasonably dangerous. And that's what, while obviously this court is looking to its own guidance, when you go outside of the state, there's been a few cases on it. The Burkowski case is one that I would urge the court to look at because the court was faced with the exact same questions and asked the same questions about how do we draw the line? Where do we figure it out? And the answer is basically you have to look at whether, as it's designed, is there something wrong with it? And there's nothing wrong with a vehicle that's safe as designed.
Well, okay, then go back, then kind of returning to what Justice Bullock was asking, and I initially asked about, then, so you pass that consumer expectation, and maybe there's an expectation, and it is a defect, not in this case, but in whatever case, there is a defect. So you go on to examine, is it unreasonably dangerous? And you employ the consumer expectation test to the extent it can be used. How is that test different than finding if there's a defect?
I think in certain instances they are similar. I do understand that there's some confusion there, but again, the first thing you look at is, was it safe as designed? And if I draw the distinction, let's look at the Vineyard case, which was the subject of much discussion in the appellate court, and frankly, I think tells us a lot. In Vineyard, they admitted that the lack of rollover protection was a defect. And then they went to the next step and said, but did it make it unreasonably dangerous? And the court said, no, because it's known that if the vehicle doesn't have this rollover protection, they use open and obvious, but they're really talking consumer expectation. The ordinary consumer has an expectation there. And so you can separate these concepts. And back in the early cases, that's exactly what the courts were doing with it. And I think that it's particularly appropriate here because the main argument that the plaintiff makes is that if you have a safety device that you could put on a vehicle, you should do it. And we know that's not the law. There's risks of anything. There's a risk of a ladder. Any product has a risk associated with it. So that can't be the test. We have to look for something more. And in this area, and I do understand the law has to apply across the board, but I think the court has already drawn those lines and explained that you have to show a defect in the first instance, and that cases where there was something wrong with it, when it from the very beginning, again, the park to reverse, I think, is one of the best examples of it. There's a defect. Other cases, there's the escalator case. Again, I think that's Estabrook. An escalator case, they said there was nothing wrong with it when it was designed. There's just simply nothing wrong. Plaintiff cannot point you to something that was wrong with this vehicle. All they say is you could make it better. And in these times where these emerging technologies are out there, that's always going to be the case. There's always going to be something new, better coming down the line. And if the law is every time there is something new, you need to put it on your vehicle, then manufacturers or insurers, it creates problems for anyone in the industry to try to make changes and design and go forward. That's why the concept of phase-in is so important, because manufacturers need to be able to do that as they're moving forward.
Council, does it make a difference that the LDW could have been installed in this Forerunner? It was in a previous or maybe a subsequent edition of this vehicle. Does that make a difference in our calculus?
It doesn't make a difference, because that would simply be saying that because there's some alternative design, you have an obligation to include that design. It sounds better from the plaintiff's perspective, of course, to say, well, you did it in some other model, you should have done it in here. Here, by the way, it wasn't on a trim package. It was the Forerunner line did not have it on any of their vehicles in any trim package. But it sounds good, but it doesn't change the legal analysis, because the legal analysis is, was there anything about this that was defective? And if all you're saying is you should have made it safer, the law, the Rogers case, there's many, many cases in this jurisdiction that have said that, a few of them, Rogers, the Rashke case, the Wilson case, the Morrow case, going all the way back, that said you don't have a duty to make it the safest possible product. What we look at is the product as designed.
Is this a defect? And then under the risk-benefit analysis, at least a couple of factors seem to relate to the issue of safer alternatives and feasibility and cost effectiveness.
Well, yes, what I would say is, first threshold question, is there a defect? If the court finds there's no defect, there's nothing else to do. At that point, the case has been decided. But if the court finds there's a defect, then you go to the next set of questions. We all understand there's two tests of unreasonably dangerous, consumer expectation, risk-benefit. I think that the Brethauer case controls on consumer expectation. I think it's very similar in terms of everybody understood what a seatbelt is designed to do. The language of the opinion talks specifically about performance. It's about how did you expect it to perform? The ordinary consumer with a seatbelt expects the belt to protect them. The ordinary consumer with regard to a vehicle expects they need to operate their vehicle. When you go to the risk-benefit analysis, I don't want to miss the point that the risk-benefit analysis that the court undertook was error, because the court said, we're going to look at the LDW design and see the risks and benefits. The law is crystal clear. In fact, the opinion cites it. Galanka says it. You look at the challenge design. You look at, as it's designed, what were the risks and what were the benefits? And the ultimate question there is whether or not the article was it reasonable to continue to market the product in the condition it was sold with knowledge of the danger? And we would say the answer to that is no, for a number of reasons that include the fact that it's reasonable to rely upon the driver. The system is not one that's going to eliminate. We know we can't eliminate the danger here, because drivers are always going to do what drivers are going to do.
Well, Counsel, can I ask you a question there?
Sure.
If we're looking at then whether or not it was unreasonably dangerous, or whether the manufacturer should have continued to produce and distribute the product, is it at that point, though, that we should take into account the number of accidents that occur, the nature of those accidents, and the availability for the technology as the manufacturer has otherwise deployed it on similar products?
I think that when you look at on the risk-benefit analysis, you do engage in some of that. But the important point there is the measure is not whether there's a risk. There's a risk in everything, every product out there. So it's not a question of, let's see if there's a risk. And if there's a lot of accidents, which I'm sure you're going to hear about all of the accidents, that means automatically there's something that you need to do about it. It's part of the equation that you look at. But one of the most important parts that you look at is the consumer's expectations and what the obviousness of the danger, and you go through all those factors. Can you eliminate the risk? No, you can't. With that, if I may, I'd like to reserve the remaining time.
Thank you. Hey, Mr. Gelfi?
Thank you very much. Brent Gilfie on behalf of the plaintiff appellant. With me is Lynn Shumway. We're both 1987 U of A law grads, so we're happy to be back here in this room where we spent a lot of time. Yeah, okay. ASU undergrad, does that count? So, I say this with all due respect to the court. That is not Arizona law. What you just heard is not Arizona law. It is not a two-part test. It is very clearly defined in the Dart case by this court as the following. Applying the hindsight test, which I think answers your question, Justice Timmer, about what are some of the differences. But applying the hindsight test, the question, singular, is whether, given the risk-benefit factors outlined in Burns and any other factors which may be applicable, it was unreasonable for the manufacturer with such knowledge to have put the product on the market. If the single question is answered in the affirmative, the product is not only defective, but it is also unreasonably dangerous. It is a one-part test. It is a uniform, fused, unified, holistic test.
You're right. What you quoted, obviously, it says that, but it also said earlier on, it's a defect is separate. And Ridnour picked up on that and said defect is separate. Candidly, I find Dart inconsistent. Nobody here was on the court then, so I can say that. But it was inconsistent in that, and it's caused some confusion that has filtered down. So rather than addressing at least some of that confusion, how do you lead us out of that confusion? What should it be? And that's what I was getting at too. Of are we going to have two separate things, separate tests? Are we going to have a single test? How should it proceed?
Two things. If you look at the cases, there's about 15 cases that everybody has cited here. They are there's one that's pre-Stapley, where we adopted 402A and the risk-benefit factors. There's 3 or 4 others that are applying negligence principles or breach of implied warranty principles. That's the language they use. The product wasn't defective. It was made for this purpose and it served that purpose. That's not strict product liability design defect language. She cites Vineyard. Vineyard is a negligence case and a res ipsa case, not a whiff of strict product liability in it. So here's the way I resolve it. I've read every one of those cases. Dart, Ridnour, you go through the list, Jimenez, look at what the court actually did. They used compound language, which 402A does not do. They use compound language, defective and unreasonably dangerous, which is not the language of 402A. Language of 402A is defective condition, unreasonably dangerous to user. That's a one-part test. But look at what courts did. They applied the risk-benefit factors, and if the risk-benefit factors said that the risks outweigh the benefits, the product was defective. Here's language that they use. Defectiveness is proven through showing unreasonable dangerous, not independently. The defect is the unreasonable risk. So let's do this. And here's I think, some analysis that will help us through this thicket. Turner. That's the ice machine case. Remember this poor kid, I think it's his first day on the job. Ice machine, it's going to cut the ice into little pieces. And he reaches his hand in there because he has to make sure that the pieces that aren't cut properly get rerun through the machine. He doesn't know it. There's a gate, closes, whacks off 3 fingers. Okay. Let's apply Toyota's analysis. That machine did exactly what it was designed to do. It did not take into, as an aspect of its design, the idea that somebody's going to reach in there. So it didn't include a guard. So, but how did Turner rule? And Turner was cited favorably by Dart. The Turner court went through the risk benefits analysis based on the risks. It then backed in and said the product is therefore defective. Turner uses language, defect and unreasonable danger. So does Ridnour, so do some of the others. Even Russell uses some of that language, right? But the and is always followed by an analysis that's a one-part analysis. Let's apply these risk-benefit factors and see if they weigh in favor of defect, the product is defective. It is uniform.
Well, let me ask you this, because I gave a lot of thought to this. I can understand conceptually that you can have a defect that's not dangerous or not unreasonably dangerous. It's just, something doesn't work as it had a
Right.
defective
Manufacturing
design.
defect.
Right, but it's not dangerous. Can you have something that is unreasonably dangerous under our law on this that is not a defect?
No, and here's why.
And can you give me an
Burns
example?
risk-benefit factors factor into things like one of the things sort of like hazardous products, knives, and the like. So you've got 2 or 3 of the Burns factors that say, what is this piece of equipment intended to do? Can we do it with any other piece of equipment? You can't cut lettuce without a knife kind of thing. So therefore, we accept those risks, and those factors are going to factor in the concern that you have. Knives are dangerous, but they're not defective. And there are a lot of things like that. And if you look at the risk benefits factors, which are designed to protect defendants, manufacturers, by the way, from lawsuits where there's really nothing they could do, right? I put out this product, there's nothing I can do to prevent some person not very bright doing something stupid with it. That's one thing. But where there is something that they can do, they must. And now let's talk specifically about this case. It is the most compelling case I've ever had as a plaintiff's attorney. And here's why. You talked about statistics, Justice Montgomery. Unintended lane departures are horrific. Represent about 20%, we cited all this, and there's factual support. 20% of all accidents, but the majority of deaths, because all those physical forces come together, right? When cars collide, that sort of thing. That studies from as far back as 2005 determined that 85% of those could be prevented by lane departure warning systems. The Insurance Institute of America has done those studies. Academics have done those studies. But more importantly, this defendant knew before 2002, because it produced cars in 2002, so sometime in the design phase, that it wanted lane departure warning on its vehicles. Why? Very candidly, in their 30B6 deposition, Toyota said, because we knew of that risk and we had a system that would prevent or mitigate that risk, we began installing it in 2002. We continue to install it every year since, and we made it standard on every vehicle except this one by I believe 2017, but it might have been 2018, the year before this vehicle was built.
Counsel,
And
you say in your briefs that in finding a duty of care toward third parties, and you cite a California case, the Ortiz case, the court noted that foreseeability is the most important factor in determining whether such a duty exists. Isn't the law in Arizona exactly the opposite? That we don't look at foreseeability when determining duty of care?
I don't believe that's right, Your Honor. If you look at State Farm talks about the fact that the burden, strict liability places the burden on the manufacturer to do the right thing because it has the knowledge, it has the information that tells it what's foreseeably likely to happen. Just as Toyota, 17 years before this vehicle was designed, knew of these risks. Foreseeability actually is a key element that runs through the strict liability statute in Arizona, foreseeable misuse, and it runs through all of the case law. If a manufacturer can't foresee it, then I think the Burns factors are going to say they're not liable. If it's not a foreseeable, just as if the manufacturer can't do anything about it, the Burns factors are going to say they're not liable. Here, a foreseeable risk, one of the biggest risks in America, that kills 6 million accidents a year, 23% of them caused by lane departures, a huge 328,000 of them by drowsy driving, 6,000 deaths. They knew they had a system that would help drowsy drivers in this situation for 17 years.
What is the limiting principle here? The limiting principle from, as opposing counsel said, and as the concurrent said in the Court of Appeals, there's something new all of the time. I could tell you, for example, we have known for years, and we put on probationers for DUI sometimes, that you have to blow into a breathalyzer type thing to show that you're not impaired before you can start your car. That would save a lot of people's lives if it was on every single car to make sure that didn't happen. That technology has been around for a long time. Why? What is the limiting principle that is going to prevent plaintiffs from coming forward saying, well, you could have done this, you could have done that, there's a lot more you could have put on a trim?
Well, in your example, Your Honor, with all due respect, we have the Constitution. I mean, in other words, and maybe you say driving is a privilege and therefore you have to blow into this thing before you drive, but it's really not a privilege. And put it in the context of the Burns factors. People have to drive, especially in America, right? We don't have a lot of public transport. People have to drive. So it's one of those overwhelming things that outweighs other things. In other words, it's in here, the first Burns factor, the usefulness and desirability of the product. The Toyota 4Runner is a very useful product. Toyota didn't bother to address any of these issues, but I would say that one might lean in their favor. It's the only one. So let's take, again, back to Turner, specific facts on which I think this court would say that was a...
I'm sorry, counsel, I don't think I understood your answer to the Chief Justice's question. So what is the limiting principle? Why would we not then want all vehicles to have some way to ensure that people are not intoxicated when they're driving.
She may have suggested a line of cases that make sense. For plaintiffs, I don't know, but the Burns risk-benefit factors take all of that into consideration. The fact that people need to drive is a huge, overwhelming factor in favor of saying we don't want to restrict driving too much, or else people can't work, they can't take care of their families, that sort of thing. And
But
if you
it's
go down the
foreseeable
list,
that it's foreseeable that a number of people, whether they've been arrested and convicted of DUI or not, it's foreseeable that today, every day, people will get behind the wheel under the influence of alcohol. So then why would we not just make that a requirement?
because there's a balancing, and the Burns factors, if you look at them, balance that. And so with vehicles, incredibly dangerous. There's 6 million, accidents per year, but they are overwhelmingly valuable to society. We
Counsel?
recognize that. Building a bridge, they factor in how
Counsel,
many
let
people.
me interrupt you there for a moment, because we've been talking a bit about the Burns, or the risk-benefit test.
Yes.
What about the consumer expectation test here? It was a point that opposing counsel made very strongly that, here, the vehicle performed as it was expected to perform, and it's in the briefing, it wasn't necessarily laid out in oral argument, but for the fact of human error. Otherwise, the vehicle performed as it was supposed to, as a consumer would expect. If you're alert, if you're driving, you can stay in your lane. If you're not alert, the vehicle can go off the road. So why wouldn't this consumer expectation test apply?
Because by statute and by this court's prior rulings, foreseeable misuse is something that manufacturers must protect against if they can reasonably do so under the factors. The statute defines it and says foreseeable misuse is something that manufacturers need to take into account. We know people drive drowsy, and again, all due respect, everybody in this room has done this. Toyota produced a video, a marketing video showing somebody going like this, showing the warning sounding, and showing them steering back into the lane. Exactly our facts.
So let me ask you this question, and I don't mean to be disingenuous in saying this either, but we know people will be inattentive too when they look at their phones.
Right.
So why not line the inside of vehicles with technology that would interfere with the signal so that the phone won't work?
We have it. There is technology that looks back at the driver, a camera, and if they're not alert, it warns them. Toyota has it. Not in all their vehicles, but Toyota has that system.
So does that have to be on every vehicle now?
I'm sorry?
So does that have to be on every vehicle
It
now? or is
depends on the
effective otherwise?
facts. So again, look at the factors. The reason why this case is so compelling is because there was a reasonable alternative design that had been around 17 years. And Toyota marketed the fact that it put these safety systems on its vehicles. It wanted to be known as the safety company, which I want to get back to that on the consumer expectation test. So there's a reasonable alternative design that's been there for 17 years, and Toyota just made a choice. They said it. We chose not to do it. So they want to immunize that conduct. Do we really want to live in a world where manufacturers can say, I want to put an infotainment system in a vehicle at the expense of a safety system that we know will save hundreds of lives, thousands of injuries, however you want to quantify that massive risk? No. That's not Arizona's law. It's not Arizona's public policy. You have to take foreseeable misuse into consideration.
It seems like I'm thinking through what you're saying. You're advocating for the single test about the risk benefit and to go through that, and not defects separately. But I think you would agree with me, wouldn't you, that this was a 1969 Rambler. Probably not a defective design because it didn't exist back at the time, correct?
Absolutely.
But if you
yes.
went through the risk benefit, wouldn't you come through, well, it's free. It's still unreasonably dangerous.
Yes, it is. But there's no alternative design. There's no other way to modify it. There's nothing you can do about it. Here, Toyota admits the cost was inconsequential. In other words, you have a vehicle that it costs you nothing to install a safety system that will prevent massive injuries and death, and you choose not to do that. Arizona does not let that choice be the choice. It just, and in every case, again, I would ask you, look at Ridenour, look at Jimenez, look at Dart. They may use a bifurcated language. Never has a court said and really applied it. Always, they apply the risk-benefit factors and they say the unreasonable danger defines whether there's a defect in the vehicle. Back to consumer expectations. In their brief,
Well,
Toyota for the first.
before getting there, collapsing the defect prong, it may, I think, in probably all of those cases, there was a defect and it was fairly acknowledged. Here, I don't see a defect unless you go to the second part of the analysis. There was nothing wrong with this car. It didn't have exploding tires. What was wrong with it was the driver. The driver violated the law and therefore operated the vehicle in an unsafe fashion. If we collapse those two things and say anything that causes an accident in an unreasonable, anything that is unreasonably dangerous is necessarily defective, it seems to me that basically you are asserting a rule that this state has not adopted. We typically do not follow California tort law.
By the way, California was a duty case, but let me be clear about something. You're worried about the extremes. The extremes don't happen. They don't because Burns protects against it. It's a manufacturer design test to make sure that frivolous lawsuits don't get brought, because you have to plug all that in to these risk factors. And when you do that, it's not unreasonable. Again, back to Turner, the kid that stuck his hand in there, clearly an unintended use. The machine was perfect. It did exactly what it was supposed to do when breaking up and chopping up ice, but it chopped off some fingers because there was no guard there. A minor risk compared to what we're dealing with here,
But
Your Honor.
what we're dealing with here is the Turner case, dealing with the hand and the ice machine. Here with vehicles that there is consistently evolving technology. There's constantly new safety features that are coming up with the evolving technology. What do we make of the fact that lane departure warnings are not required under federal law? Other, like backup cameras are recently required and other technological features. So what do we make of
The Safety Act of 1966 doesn't, the requirements of federal law are half the equation. State law and state juries are the other half of the safety system in this country. And we dealt with that in Varela, Your Honor. We dealt with the idea of preemption, and we dealt with the idea of these emerging technologies. Burns deals with it. You know how it deals with it? Is there a reasonable alternative design? And the reason why this case is so compelling, it's a design this manufacturer has had for 17 years before this vehicle was designed. So the restatement third, which I know we haven't adopted yet, it's purely a reasonable alternative design test, which is viewed as far more friendly to defendants. Here, so even under a less friendly analysis, the restatement third says, can the plaintiff show a reasonable alternative design? Yeah, we have one. Toyota admits it works. It was really effective. That's why they installed it for 17 years. They just chose not to do it on this one vehicle out of their whole fleet. That is design defect. They can't make those choices.
Under your analysis, when does liability attach for failure to include LDW in the Forerunner model here?
At the time it was designed and built, Your Honor. So when it left Toyota's hands, based on Toyota's knowledge of the foreseeable risk, it had a defect because they had a solution that prevents all these injuries. They didn't implement it, and it cost them nothing to do it.
So liability would attach to a Forerunner when, in 2004, 2003? How far back would liability?
Again, apply the risk-benefit test, and I think Toyota would say to that, we couldn't wick it all the way through our system in that amount of time, but they could here. And really quick, consumer expectations, Venn diagram, consumer expectations, risk-benefit. Toyota wants to conflate those and say that if you don't have consumer expectations, you can't have risk-benefit. That's not Arizona law. And Toyota deliberately sold itself as the safety company, put out the video saying our cars will help you get back into your lane, and told consumers to expect that, as did the federal government. Beginning in 2001, the federal government told Toyota in a letter, and other manufacturers, put this stuff into your vehicles now. 01. And they didn't do it. Consumers should have expected that. Thank you very much. I appreciate it.
Thank you, Mr. Gelfi. Okay, Ms. Lubish.
I've got a lot in a minute and 49 seconds, so try not to talk too quickly. First of all, I think the court's recognized that there are a series of cases that have said you have to prove a defect first. But I want to talk about the Turner case because I think what counsel said is a misreading of it. The court in Turner said, we acknowledge they're talking about the defect. We find the parties tacitly recognized the lack of a safety guard is a defect and pass to the determination of whether that defect is unreasonably dangerous. Right there, the case the plaintiff wants to rely on says, first we do defect, then we go to unreasonably dangerous. Why do we do that? Because there was a question about, can you have something unreasonably dangerous without it being defective? Whiskey, for example, and I think that might be the example in the restatement. Whiskey, somebody might say, is unreasonably dangerous if somebody gets drunk and does something bad. Does that make it defective? No. But I think the most important point is this question about the limiting principle, and what would that limiting principle be? Plaintiff's counsel doesn't like the example of a breathalyzer. What about a speed limiter? Why don't we have speed limiters on all vehicles? Because a speed limiter would certainly prevent somebody from speeding, and the statistics are going to show you how dangerous that is. So really what you have here is a slippery slope that plaintiff wants to go down that says, every time I can find some new technology, I'm going to say that that makes it defective. How do we resolve that? The limiting principle is first there has to be a defect. And once you demonstrate, and a defect is defined, certainly in 402A, it's defined, and I don't have time to read it now. The Dart case uses comment G. The Ridenour case uses comment H to define what the defect is. That's the limiting principle that addresses and resolves the question about when is it a yes answer and when is it a no answer. Thank you very much. We would ask that the court vacate the Court of Appeals decision and reinstate the entry of summary judgment. Thank you.
Thank you, counsel. All right, I think both sides for excellent argument and briefing on this. It's interesting and difficult issues, and one that we realize the ramifications for. We will discuss this and take it under advisement and issue an opinion in due course. Now, from here, what we're scheduled to do is answer questions from the law students for the next 20 minutes. Before we do that, what I want to do is thank the people that are responsible for putting this together. First and foremost, well, not putting it together, but being here is council that are willing to come here today. It's very important to have the students be able to see argument and advocacy in real life and see the stakes. And you both did an excellent job in demonstrating that for them. And we're very appreciative for you coming down here. Also for the people that put it together, the first argument, I think I did leave out, so I'll start with them, the clerk's office, who actually are here officially to make this a go. We appreciate it. Sorry I left you out, so I'll say it twice. The clerk's office. And you need to tell your friends who are here at the first argument. So we appreciate the clerks, the communication team, the IT team, the security folks, and the folks that got us down here. It takes a lot to come down here, but it's very worthwhile to us to come to U of A every year and see the students and have the students see us. So you're always welcome, by the way, to come to Phoenix or even watch us online. As you can see, you can watch us live stream, and even if you have a class, you can watch us after, because it's there for your viewing pleasure at all days of the night, of the week. So with that, what we're going to do is go into question and answers. You don't ask questions about this case or anything having to do with it, because that's inappropriate. Or the first case, if you happen to be here for that. We don't discuss the cases, but we're happy to answer other questions. Counsel, you can leave or stay at your pleasure. It is really up to you. So don't feel bad about picking up and leaving, because I understand you're busy, but please, we're happy to have you here as well to even answer questions if they ask you that. So with that, I think do we have microphones around, or do we? Yes, we do. Oh, there he is. Okay. So questions. And I'll warn you ahead of time that if you don't have questions, we just start talking. So yes, way back there. Yeah, or call a law clerks. That's the other thing. Who I also forgot to thank.
Thank you. I'm Zach Kaufman, a 3-0 here. I just had a question more meant for potential future appellate litigation and Court of Appeals are in front of you. And because I work for an employer that does worry about citing a case and then it comes before you, and now how the law would be applied be different now. And so I was just curious if there's any guidance that would be appropriate for you to share on citing cases knowing that they're going to be challenged and be heard in a higher court soon.
You mean cases that are kind of in process that might still be heard by us, but they've been
Or
recently decided?
say like I cited the appellate version of a case that's knowing that you're going to hear it and probably change what the holding is in that case because say it's going to impact other litigation my employer navigates.
Okay, so you're the shill for your employer here asking this question. I got it. Great. The nice thing about being the Chief Justice, there's a lot of nice things about being the Chief Justice. Among them is that I get to delegate questions. And so I'm going to do that and also cleverly introduce each member of the court as I do so. So I'm going to turn this over to Vice Chief Justice John Lopez to answer.
All right. Well, if you believe that an appellate case that you're relying upon to prevail in the case is on review and you are leery about its prospects of survival, I would highly recommend that you find other authority as fallback. But beyond that, make sure that the citation to the case indicates to the court that is considering your argument that it is on review. I think as a matter of candor to the court, I think you'd want to signal that. But I think that the dilemma that your employer faces is self-evident, as is my advice probably. So good luck.
Well done, Vice Chief Justice. And I should let you know that Arizona is one of the few states, I think the only one I know of, that has a Vice Chief Justice in our Constitution. So both of my term is for 5 years, his term is for 5 years. And then unless he messes it up, we'll take a vote to see who will be the next Chief Justice, and it will likely be him unless you do something wrong. So, and he has been on the court since 2017, correct? Great. Another question right there.
I just wanted to know how much time goes into each case that you like. You guys obviously have to read it and you have to know things to ask your questions. How much time do you guys actually spend on case by case?
Oh, great question. Well, we had a fun weekend. Let's put it that way. So I will turn this over to Justice Clint Bullock, who has been on the, I forgot to say, and Vice Chief Justice, it went to ASU, so I'm going to do that. I went to ASU as well, so that's 2 ASUs and 1 University of California at Davis, and he's been on the court since 2016. So if you could please answer that.
Yeah, sometimes 5 or 10 minutes on it. No, I can say that jokingly because Chief Justice Timmer is correct and heard me say today. In future calendars, can we try not to do 2 OAs the day after a 3-day weekend? Because that means there is no 3-day weekend. There isn't even a 1-day weekend, but it really, really varies according to the case. For some of us, some subject matters are entirely new. I had to do, for example, we had a water law case. I had to do months of preparation just, in terms of doing a primer on water law before I could even look at the briefs intelligently. Other times, constitutional cases, I teach constitutional law. And so looking at a First Amendment issue, oftentimes I'll be so far up on the learning curve that reading the briefs, I'll hardly see anything I didn't know. And there's a vast continuum between those two things. So we first take a look at the cases when they are presented to us on petitions for review. And at that point, we have a summary and a recommendation from our staff attorneys, and they are subject matter experts. I encourage you, a lot of people don't know the staff attorney's office even exists. It is a great internship opportunity. It's basically the same kind of work you do as a law clerk. And my law clerk, Sam, worked for the staff attorney before he started clerking for me. And so we've already looked at the case, and my numbers are probably way off, but we get about 1,200 or so petitions for review and grant review in about 50 cases, but we've looked at all of them. So we've taken a first cut. Then we have a conference to review those petitions. And so we've looked at it again. And then finally, after all of the briefing, we get briefs from both sides. We often get amicus briefs as well. And our clerks then present memos summarizing the law, making a recommendation. So even the easiest case takes many, many hours to prepare. And sometimes I usually try to leave for 2 cases a solid 7-day week to prepare for two cases, knowing there will be some interruptions every now and then. But it really does depend, and a lot of work definitely goes into it.
I will have to say that Justice Bullock was so taken with that water case that he now has a love of water metaphors and analogies. And in practice, you can go through all of his cases that he's written, and you're probably going to find a water analogy there, right? And so,
That is
all right,
true.
question over here. Yes.
Yeah, my name is Maurice. I wanted to ask, what is your opinion when it comes to nationwide injunctions? I know in the past few years, not even years, like the past few months, there's been a lot of talk about that when it comes to this administration, the Supreme Court in general. What is your opinion?
The question is, what is their view on nationwide justice?
Injunctions.
Injustice. Okay. Got it. Got it.
Injunctions.
Injunctions.
We don't like nationwide
That's very different
injustice.
than justice. I was going to say I'm for justice nationwide. That's an easy one, but okay. All right, then let's turn to justice. Well, coincidentally, I too have always wondered what Justice Bean's opinion on nationwide injunctions was. So this is a timely question. So Justice Bean was appointed in 2019 and is a graduate of University of Arizona's Law School. Justice Bean.
Now the expectations are
Yeah,
soaring.
this is just very good question. And I spent a lot of time in Trump versus Casa. I believe that was the case. Is that the case? And both sides had interesting takes on the issue. I mean, I don't know if I feel comfortable like opining on this, though.
Nobody's gonna make you.
Yeah, I mean,
It's not going to come before us.
well, I mean, we said, well, I won't go there. We said something else wouldn't come before us, and it did. Yeah, I'm going to take a pass on that, and I took a pass on answering questions in this hall before as a student, so I feel I can do. I think it's comfortable. I feel comfortable. I have precedent in doing it here, so. I just don't feel comfortable answering that question, given that it's such a hot topic issue. Even though it's not likely to come before us, I'd rather not answer.
And I think we don't want you to feel like we're dodging the question. We are, but I don't want you to feel that inappropriately dodging the question. I think what you've touched on is something that even though that issue won't come before us, we are very attuned to the perception of the court in Arizona, one we want to nurture, which is that we are really we're not political. Now, the question you asked, and certainly the issue of nationwide injunctions, is a political hot potato. And even by taking sides or expressing opinion, it's considered taking sides. It's amazing. It really is. You talk about free speech. I know we're going to be down here talking about it in a couple weeks, you said. And We, though, are reluctant to publicly speak on certain things for that reason, because above all, we want to nurture not only the fact, but also the perception that we really are deciding cases that come before us fairly, impartially, and on the law as much as humanly possible. And when you start to opine on a lot of political questions, even though you have a perfect right to do it, with a lot of people, that is makes them wonder, oh, are they really just that in tune to politics and deciding things on that? So I think that's what some of the reluctance is on that. So, but good question. Other question over here. Yes.
I have a question about the Arizona's legal deserts that have been in the news a lot lately. Recently, the one-year criminal law education proposal was struck down. I was wondering if you are currently considering expanding duties for LPs on the criminal side.
Oh.
I kind of thought about, the civil system, we operate on a tier system in Arizona. And I was wondering if there was maybe a way to do that on criminal side too. And as far as LPs go, testing for tier 1 might be the misdemeanor crimes that they can be licensed for now, and maybe tier 2 could be more serious felonies, and tier 3 could be, up to and including, or maybe up to death penalty cases, like the proposal that there was.
Yeah.
Is that something you thought about, or?
I can feel Justice Bean saying, please don't put this back to me.
I can handle that
Can you
one.
handle that one? Okay.
Or at least I hope I can. A great question. And we, about the, I think it was 1 or 2 year ability to take on criminal cases with a specified, specific curricula. We're always, this court, what I love about serving with my colleagues, we're always open to out of the box ideas. That's how we have the LP process and program, because we thought outside the box. And I'll speak for myself. I'm not adverse to opening up the LP. The issue that I personally have, the possible rub that I have, is in the criminal area because of the liberty interests that are involved. And if you don't go through a 3-year, and this again, just speaking for myself, 3-year rigorous program like law school is, and then study for the bar and pass the bar and show that basic minimum competency. Outside of that, I would have some, again, I'd have some reservations about opening up somebody that hasn't gone through that process to dealing with cases as serious as criminal cases where there is, again, the potential loss of liberty. And if you're ratcheting it up to being able to do death penalty cases, possible loss of life. So I would personally, again, be okay with looking to see where you would like to maybe make some increments, or if somebody wants to make a proposal for increments for LPs to get more involved in the criminal process. I would definitely welcome that as a 17-year prosecutor and former trial court judge that presided over criminal cases. I think it could work. But initially, I have a little hesitancy about that just because of the subject matter involved.
Okay. Oh,
I want to touch on the other aspect of the question too, about the way it was reported that we were considering authorizing people with 1 year of law school to then go out and handle capital cases. That was hyperbole at its finest. As Justice Bean mentioned, we're willing to hear all kinds of ideas, and the fact that we were entertaining an idea didn't mean we were advocating for it. It simply meant we were asking for input, and we were getting that input. And then people decided to run to the extremes and say that we were preparing a proposal for a program that would authorize this. Again, speaking for myself, my experience, the members of this court are willing to entertain all kinds of ideas to address issues of concern about access to justice, how well our system performs. And just because we've asked for input on something should not be taken to mean that we are preparing a decision to then enact the very idea. So I encourage caution.
And that was Justice Montgomery, who's been on the court since 2019 as well. Yeah. And I went to ASU Law School. So there you go. Okay. Okay. I was going to switch over to this side. Is there, and by the way, I had also forgotten the fact that we have our law clerks. Each of us get 2 law clerks, and we also have externs as well. But we have brought the law clerks down with us. Say, raise your hand, law clerks. Yay, yay. So I think most of them, but not all of them, graduated this past year. And some have been out for a while and came back. Raise your hand if you went to U of A Law School. Yeah, so a lot. Okay, so quite a few. So, all right, question on this side. Yes.
My name is Erica Kuhn. I'm a 3L. I would like to understand better how the court, the Supreme Court of Arizona, how you decide the scope of an issue. Specifically, for example, recently, maybe a year or 2 ago, there was the issue of the older abortion law that was dealt with, and the court, I believe, decided that the scope of the issue did not, for some reason, include whether or not the legislation was constitutional, perhaps. And I did not understand how that's not always within the scope of the Supreme Court is to decide when things are constitutional or not, because I know you have that opportunity. So I'm sure it's judicial discretion, but how do you make that?
Yeah, well, and I'll just say briefly before I turn it over to, I think we're up to Justice King next. On those cases, for the most part, we have a role. Our role is the judge, and it's not the attorney. It's something that, frankly, that the most frustrating thing about being an appellate judge, I've done it for 25 years now, and the most frustrating thing is seeing missed arguments or different arguments, different ways people have decided to proceed. But that also it's not a very humble thing to say, because I see this little sliver of a case, how they've decided to present it to me. I don't know what's in the background of why they wouldn't make the argument, which I think they should be making, but they've made the choice. And I trust the attorneys to tee these things up. So for the most part, the scope of an issue we decide is what has been litigated to the trial court, and it's made its way up to us. We resist the temptation to reach out and decide issues that aren't before us and haven't been briefed. Candidly, on the abortion case, as I recall, that wasn't an issue, the constitutionality. The issue was simply, if I recall it, the statute. It's amazing how quickly you forget. But that wasn't the issue, but I think it was the statute that did it repeal the old 18 whatever it was law. So really, despite the very hot, greatly interest, obviously, issue, it was actually a matter of statutory interpretation. And so we don't reach out and decide things that aren't given to us. If the initiative hadn't been passed and then it would come around again, what would happen? And I think there was a case bubbling up doing just that, challenging the constitutionality of that, and then it can come up and make its way. But really, we try to be very, and that's actually one of the reason I felt strongly about answering instead of passing off completely, is that's really something I feel deeply about. Nothing worse than when I was an attorney and a judge starts taking over my case and deciding things that are not before, that I didn't have a chance to weigh in on. And as one lawyer famously said, Judge, if you're going to try my case for me, try not to lose it. So, Justice King, I hate to usurp you, but this is Justice Kate King, who has been on the court since 2021, also a proud University of Arizona Law School graduate.
Thank you.
Why don't you answer?
Yes, thank you for that question. And Chief Justice Timmer, you did a fantastic job. Yes, so the issue that was presented to us was a question of statutory interpretation. And there's a long, convoluted procedural history that led up to this, the case that was before us and that was decided, I guess, 2 Aprils ago. But if you look at the end of the opinion, we note there were actually, in the original lawsuit, there were a variety of different constitutional claims that had been originally asserted. And if I recall, we remanded to the trial court for further consideration of those constitutional issues. But with the immediate legislative action that took place thereafter, it kind of mooted the case. So there were remaining constitutional claims that had been asserted, and we said, to the point, we don't reach out and grab issues that weren't presented to us, that those constitutional issues need to be fleshed out in the trial court first, and then they can come to us. Thank you.
Of course you can.
I wanted to, and I agree with everything that the Chief Justice and Justice King just said, but I'm going to put a finer point on it. In litigation, especially, and this is not a case where you have a pro per party who may have overlooked a dispositive argument. That's a little different. That litigation, as so much of our litigation, involves very sophisticated lawyers and clients, and often parties will very specifically, strategically avoid raising particular issues for a number of reasons. And so the issue, as was explained by the Chief and Justice King, was a very discrete statutory interpretation issue. So for whatever reason, the issue was not presented to us, and so we did not have the opportunity. And had we injected the constitutional issue into the case, that would have been would have raised eyebrows, I think, correctly so.
And actually, interestingly enough, in Arizona, if there's something, the constitutionality of a statute is challenged, you're supposed to give notice to the Attorney General to allow them to input, because they're there on behalf of the people to be able to defend the constitutionality of statutes. So there's a number of reasons you wouldn't bring things up, but just so that no one goes away with the wrong impression, we're not so tied that we can't vary a bit. So in other words, if there are some occasions that we would vary, statutory interpretation is a good example. Even though if the parties miss and don't argue the right things for statutory interpretation, because it has a public impact, we're not bound by those arguments. And of course, we're never going to oh, sorry, you're going to go to prison for 20 years, or be put to death just because your the attorneys miss the argument. So any kind of fundamental errors. So there are some exceptions to that. But as a general matter, we take what the attorneys give us and rely on them to make those decisions and I'm looking at you guys and bring it up. Bring it up.
So I had just
of
one
course.
really quick thing, and having done a lot of cases from the trial all the way up the appellate ladder, you probably haven't made a record on that issue. And so we would be very, very reluctant to ask parties to brief an issue in which they have not had an opportunity to make a record.
And I know we're a tad over time, but I want you to hear from all of the justices. So if you have to go to a class or have to, go anywhere, please don't think of it that it's fine to get up and leave. So Lee has a question. You're right there.
I was going to say I'm a graduate U of A Bachelor of Law, and in February I came here and there was a talk, and I complained that they were trying to push that Bachelor of Law, and I said, I've been having a hard time convincing people that this is a law degree and not through the School of Government and Public Policy, that it's actually something that, people were scratching their head. And a Superior Court judge said, come afterwards, I want to talk to you. And that's the first time I ever heard of the paraprofessional program. And I'm taking classes currently at PIMA. And I think there's quite a few people here that are probably at PIMA because of that opportunity for taking the paralegal classes and then substituting, and there's different ways to get to that paraprofessional. But as far as, say, the criminal law, I look at the caseload, say, for DUIs. Could that be something, or could there be a cutout for something in criminal law that potentially, we could really get in and make a difference as a professional?
Yeah, and I will, because she hasn't had a chance to speak, is Justice Mary Elena Cruz, who is our most recent addition to the court, and a welcome addition at that, and is also a graduate of the University of Arizona College of Law. So there you go.
It's wonderful that this question came to me because I don't know if you know, but I'm proudly known as the godmother of the legal paraprofessional program. I'm very supportive of that program. I come from a rural community, one of those legal deserts in our state, and one of the reasons why this program was instituted to help meet the need that is not being met. Your question as to the potential expansion of the legal paraprofessional reach in the criminal area is interesting. As you know, legal paraprofessionals who practice in the criminal space may do so in cases where there is no prospect of jail time. Yes, that's a limitation that we thought would be appropriate to place. That happens sometimes because the statutes don't allow it, or because in some communities there's a decision made up front that the prosecutor will not seek jail time. And there's, at least in my community, I know at the city court, there's a red stamp that goes on there. And not only does that mean there is no jail time possible, but it also means there's no right to counsel. And so that's where the need to have some access to representation came in. DUIs are different, and the possibility of jail time, even a 24-hour period, is there. So that's not something that we have considered. And as we said before, in the context of the earlier question, we are open to entertaining any proposals that may come up. We hear in the community a lot of different ideas, probate, but in terms of DUI, that's not something that we're currently considering. We have, and by we, I don't mean we as a court, it's not a formal proposal before us, but I'm a member of the Commission on Victims in the Courts. We've looked at whether potentially there could be an LP request for victim advocacy. Most victims across the state do not have representation, and they're not at risk, right, of losing their freedom. So there's the potential for that, and there are many other areas that could eventually be covered by legal paraprofessionals. But at this point, DUIs is not one of them.
Okay, well, I'm feeling a little badly that I didn't get his own question for Justice Montgomery. So does anybody have like a really difficult one for him? Right there. Oh, well, then anybody else have a question?
So I remember we had a case one time where I think Chief Justice Timmer told an attorney, sometimes when you're throwing a softball, it's okay to hit it. So
Okay.
come on.
Last question.
I heard Chief Justice Timmer say that something that was really frustrating about being a judge is when attorneys mix arguments. I'm curious what perhaps a favorite aspect of being Supreme Court judge is, or perhaps the most frustrating.
So one of the best thing about it is I get to sit around and read, write, and think all day. The frustrating aspect, yeah, that is a frustrating aspect because there are times where we'll look at a particular case and think, if they just would have raised this issue, we could have resolved much more in an area of law that we know may be crying out for additional clarification. But the other thing that's great about this job too is I get to work with 6 other people who are incredibly smart and dedicated to wanting to do the best for the people of Arizona. I've got great clerks who I get to work with, who I get to bounce off ideas off of. And so, really throughout each day, it's the best environment to be able to serve the people of Arizona and to fulfill what I guess has been, a lifelong commitment to public service. And so that makes this job great. And thank you for the softball.
All right. Well, again, thank everybody for being here today and for your attention. And frankly, we really appreciate that you dress as you dress every day to school. I know, but we do appreciate you showing that respect, not for us, but for the court, because it is important to do so. So thank you for that. And with that, we will stand adjourned for the day.